Welcome to Section 4 of the Special Education Video Tutorial Series. This presentation is provided by the Parental Readiness and Empowerment Program, which is a program developed by the Lawyers Committee for Civil Rights under law. PREP works to ensure that parents have the tools to advocate for their children so they have access to a quality education and greater educational opportunity. More information can be found at our website, prepparents.org. We offer helpful information, but this is not a substitute for legal advice. We do our best to be accurate, but rules can change and may vary by state and district. Section 4 will focus on what parents can do if they disagree with a school's decision related to special education. If a disagreement occurs, first see if you can solve it by discussing your concerns with the IEP team. You can often fix an issue quickly and effectively by using clear communication and advocacy. However, sometimes even clear communications will not change the situation. If the issue remains, you have the right to follow a more formal complaint process under both the IDEA and/or Section 504, the two federal laws providing protections to special education students, which we've discussed in prior videos. Parents' rights differ slightly under the IDEA and Section 504. As mentioned in the previous videos, the IDEA is more specific about a parent's rights, a school's obligations, and the timelines which must be followed. Section 504 provides less specificity about the complaint process, but it still provides important protections including the right to impartial hearings to resolve complaints. Additionally, Section 504 provides different options for where and when to file a complaint. In this video, we will discuss the complaint process under the IDEA and then the process under Section 504. In writing the IDEA, Congress tried to create a complaint process that would resolve disagreements as early as possible. To achieve this goal, the IDEA requires local educational agencies, or school districts, and states to provide parents with the opportunity to challenge a decision when they believe that the school district did not follow all the rules or properly consider all the evidence in making their decisions. Parents can file a complaint through an impartial hearing by filing a due process complaint. For example, you may challenge a decision by the eligibility team that your child does not qualify for the IDEA's protections. Or your disagreement may be more detailed, such as if you disagree with the IEP team over the specific services your child should receive under the IEP. The complaint can be related to any stage of the special education placement process, including actions related to identification for special education evaluation, evaluation for special education services, the educational placement of your child, or the provision of a free appropriate public education, or FAPE, to your child. The IDEA provides minimum requirements for the complaint process, including what should be included in the complaint, the processes to resolve the complaint, and the timeline for resolving the complaint. While the IDEA provides general requirements, parents should know that each state may adopt these requirements in a slightly different way. So we recommend that you also contact your state's Department of Education or talk to school district staff to learn more about your state's specific rules. A complaint should include the following pieces of information: the student's name, the student's address or contact information if the student is homeless, the name of the student's school, a description of the specific problem concerning the child and facts related to the problem, and ideas or suggestions to resolve the matter. You don't have to come up with your own complaint form. The State Department of Education must provide parents with a model form to submit a complaint. And you're not required to fill out the model form, but can also help to make sure that you provide all the necessary information. The violation must have occurred in the last 2 years, although there are exceptions to this rule in some circumstances and in some states. Once you have submitted a complaint with all the necessary information, the IDEA requires a number of actions to occur so that you have an opportunity to present your complaint before a hearing officer who is fair and impartial. As part of this process, the IDEA places several requirements on school districts and the hearing officer within a certain time period, which again may vary by state. We'll go over each stage one by one. Upon receiving your complaint, the district must immediately inform you of certain rights, providing you with notice of procedural rights during the complaint process. We'll discuss many of these procedural rights that should be provided in the notice related to the complaint process. The district must also inform you about information on the availability of free or low-cost legal and other relevant services in the area. If the district has not sent you prior written notice about the subject of your complaint, they must send you a response within 10 calendar days that includes an explanation of their actions, a description of other options that they considered and the reasons why those options were rejected, a description of the evidence they used to make their decision, and a description of the other factors that were relevant to their decision. A resolution meeting must be scheduled within 15 calendar days of filing the complaint. The resolution meeting will include the parent, the IEP team, and an impartial representative of the school district who will help to see if a resolution can be reached without a formal hearing. If a resolution is reached through successful discussions, that can result in an agreement signed by both parties. The signed agreement carries legal force. Both parties must follow it. Parents also have the option of entering mediation with the IEP team to try to resolve the problem. Mediation may also result in an agreement between both parties. Many parents prefer mediation over a formal hearing since mediation is less combative and can often achieve what the parents want. If a resolution cannot be reached within 30 days of the parent's complaint, the due process hearing should occur, unless the parties request an extension. As a parent, you have many rights during the hearing, including, among other things, the right to examine all evidence prior to the hearing, the right to present your own evidence and ask questions of witnesses, and the right to an attorney. Parents can also be accompanied or advised by somebody who has special knowledge related to students with disabilities. Some states also allow parents to be represented by non-attorneys. The hearing officer must issue a final decision mailed to both parties no later than 45 days after the 30-day resolution period. In other words, the resolution must be reached within 75 days from the school's receipt of the due process complaint. These timelines may be adjusted in particular circumstances and may vary by state. Sometimes, the state provides a process for additional review. In all cases, you can also file an appeal in a court if you disagree with both the initial decision and, if applicable, the state's review. However, appeal deadlines may happen quickly, such as within 30 to 90 days after the final decision. So pay attention to the deadlines and remember, at every stage, you have a right to advocate for what you think is best for your child. Under the IDEA, parents also have the right to submit a complaint to their state's Department of Education, which must resolve the complaint within 60 days. However, if you also submit the issues as part of a due process complaint before a hearing officer, the state will not consider these issues and treat any decisions by the hearing officer on these issues as final. Each state's complaint process may differ, but at a minimum, the state must determine whether an investigation is necessary, review all relevant information to make a determination, give you the opportunity to submit additional information about your claims, provide an opportunity for mediation to parents and the school district to resolve the issue, and issue a written decision to the person submitting the complaint that responds to each claim and explains the reasons for its decision. While the IDEA requires states and parents to follow a specific complaint process before filing in court, Section 504 also provides parents with several ways to solve disagreements related to special education placement decisions, including an impartial hearing provided by the school district, a complaint with the Office for Civil Rights, or a lawsuit in court. Under the IDEA, which requires parents to start with the state and district's complaint processes before filing a lawsuit in court, Section 504 allows parents to start with any of these complaint options or choose to do more than one at the same time. The impartial hearings under Section 504 may be similar in some ways to the due process hearing under the IDEA. But Section 504 is much less specific about the timelines that must be followed and the specific rights of parents during the process. Though less specific, the U.S. Department of Education's Office for Civil Rights requires that the procedures of impartial hearings demonstrate fundamental fairness, so a parent can still make similar arguments and requests based on fairness. A complaint may also be filed with OCR, and usually with the OCR's regional office. An OCR complaint may claim that discrimination is occurring against your child, or it may claim that the discrimination is occurring at a larger systemic level to many children with disabilities. The complaint must be filed within 180 days of the discriminatory action, although the regional director may allow for some exceptions to this timeline. The OCR will then issue a letter of finding, which will either conclude there is no violation or identify violations and specify corrective actions. OCR does not need to follow specific timelines to conduct its investigation. OCR investigations can last over a long period of time. A student or parent can also file a complaint in court based on discrimination under Section 504. It's generally best to speak with a lawyer about whether this option is best for you. Now that we've gone over the basic stages of the complaint process, let's take a moment to review some key ideas from Section 4. Before you start the complaint process, it's generally a good idea to see if you can work things out by sharing your concerns with a teacher, the school, or district outside of the complaint process. If the problem cannot be resolved, however, both the IDEA and Section 504 require districts to provide impartial hearings for parents who disagree with the identification, evaluation, or placement of student with disabilities. If the problem cannot be resolved, however, both the IDEA and Section 504 require districts to provide impartial hearings for parents who disagree with the identification, evaluation, or placement of students with disabilities. Although the IDEA provides for more specific timelines and rights during due process hearings, Section 504 also requires impartial hearings to follow principles of fundamental fairness. Several other complaint options may also be available, depending on your claims and what processes you have already followed. You can reach out to a lawyer to discuss all the possibilities based on your particular situation, whether the impartial due process hearing, filing a complaint with the state, filing a complaint with the Office for Civil Rights, or a court. Generally, it's a good idea to start by sharing your complaint with a school district, but you may want to consider other options based on your particular situation. And you can reach out to a lawyer to discuss all the possibilities based on your own situation. Congratulations! You have completed Section 4 of the Special Education video tutorial series. Please click on the link in the comments below to take a brief survey. And stay tuned for Special Education Part B video series focused on issues such as the IEP meeting, discipline, bullying and harassment, and transition services.